You and Ms. Krusich either are or were in a relationship,
We dated. We don't live together. Never have lived together.
but you dated.
A little bit. Yes, Your Honor.
And both she and Ms. Gogan work at DSHS.
Correct, Your Honor. But
Okay,
there's
as do you.
yes, 30 years.
Okay.
So
And are you in their supervisory chain of command?
can I explain that to you, Your Honor? So I work for the Office of the Secretary. Mrs. Gogan, her she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where part of and where the problem lies is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, um, she sent these memes and information around to the office. And if you see the one that I sent you, she where it says in there, do you see who's on there? And I'm a coworker. Where she says, dude, I wouldn't normally message a coworker, but I can't stop laughing. So here it is in this office where you're the admin assistant to the second highest person in our administration. And now, how am I supposed to work with you every day and trust when you're discriminating and um, doing all these acts of inappropriate behavior in the workplace? And so, part of my action is I'm probably going to file a lawsuit against her. And so, I need that protection for me because, per our policy, this administrative policy, she's probably going to lose her job because of that. Um, she even the words that she uses where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. Um, I'm and then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes a comment and she's laughing her head off.
All right, guys, settle in, because what you're about to watch sets the stage for a courtroom ride that's equal parts tense and unexpectedly revealing. From the very first moment, the tone is laid out with calm confidence, almost luring you into thinking this will be straightforward. But as we move forward, every word proves this case has layers waiting to unfold.
I'm third from my boss in the department. I've been working for DSHS for 30 years, Your Honor. I've attained my MBA. I have a HRMS background. I have a Sigma SME. Um, I've been in the Army 20 years. Currently, I own my own business. All these things that she's doing uh, affect me greatly. And it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number 3, actions that violate this policy aren't limited. Um, Violations via phone, email, text, social media, electronic communication. Um, Such behavior can also be outside of work. Um, it specifically speaks to this in our administrative policy.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So,
Okay, and what about Ms.
so let me finish this. Please, let me finish this.
Well,
So, I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are up. There are putting photos online without the permission of um,
who's doing it?
um, Are We Dating Him Too? It's a site that's it's a group that's embedded into Facebook. And currently, I have a with this attorney generals to take that website down because they are putting males photos up without their permission, and there are women who are on there that are anonymous, so you don't know who it is. It could be any bandwagon person like Ms. Gogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. There's not, it's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where it's very libel and slander. So I'm working on doing that for that website. Mrs. Krusich, she was upset that I stopped dating her, and I sent her home one night. And then here, when you're looking at a couple of those, her first posting, she tried to be anonymous and said that this guy was trying to get me to go to work or to blah blah blah, and I sent the photos on there. It didn't look like I tried too hard to get her there. She looked pretty happy there. And then currently, not only does she work for DSHS, but she also has a few things of mine, and she's saying things that are disparaging on that website. And now she has her name on there, and she's identified me where I work, which is very slanderous. I'm currently in my position. I'm in the Army Reserves. I'm also a voting member for BHR in Olympia. And she knows several of those folks. So here it is, you're saying slanderous and libel things, and I could lose that spot, which is a very coveted position for me to be on a voting board here in Olympia. It took me a
Buckle up, guys, because this is where the emotion kicks in. You can feel the frustration rising as Mr. Scott lays out his side, voice steady but carrying years of tension. His attempt to justify the need for protection exposes just how tangled personal and professional lives can become. Each detail adds weight, hinting that this isn't just about words, but pride, reputation, and control.
You want to achieve? Because one of the things we don't do with the protection order process is keep people from saying bad things about other people. It's their First Amendment right. And so I get this all the time from people who say, you wouldn't believe what they say about me. None of it's true. And they post it on social media. They broadcast it to the world. They call me a pedophile. They call me this. They call me that. And we say, sorry, we can't do anything about that.
I agree with that, Your Honor.
So
I
don't know how I can do something about this.
For me, it's work. I have to.
Right. But that's
Ms. Gogan can't come.
No, I understand your position. This is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens,
So
Your Honor?
Well, we can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. I don't know if I'm pronouncing it. Yeah. And same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy, and for doing so, here's the sanction, whether it's whatever it is, firing or loss of pay, or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate procedure. You can file civil lawsuits against them for the damage
that's coming. Yeah,
that's you feel has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit, but this process isn't meant to address that. So you're not going to get any, what we would call a remedy out of this. I can't give you anything that will address it. So, I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear, I'm not saying that what you're having to deal with is too small for this or anything. It's just, this is not the appropriate process for that.
Oh, that's fair. For me, it's about exhausting all my needs.
Yeah.
So
no,
it's not a. not an end all for me. It's just another bullet in the process for me.
Yep, I get it. Certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are black males that are like me that have been dealing with this on these websites, and that's I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there. And I'll find it. I will.
Alright, guys, here's where things take a sharp turn. The moment those memes enter the conversation, everything shifts from serious complaint to chaotic courtroom comedy. The contrast between the allegations and the exaggerated online mockery exposes how a digital jab can spiral into real-world conflict. Watching this play out, you can't help but feel the tension crack under the strange mix of humor and humiliation.
Pre-trial because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the that term.
Could you repeat it?
Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay,
And I don't understand.
sir.
I don't understand. So, like, the charges would be dropped.
If you successfully,
If you did all those
you have
terms,
to abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions?
Buckle up, guys. This is where the judge steps in with a reality check so firm it practically echoes. With calm authority, he slices straight through the emotional clutter and redirects everything back to the law. His words land with precision, reminding everyone that the courtroom isn't a shield from criticism. It's a moment that resets the tone completely and exposes the limits of legal protection.
I spoke with him shortly. I didn't really get all I really spoke over, all we went over was the terms.
we had several phone conferences that were scheduled.
Yeah, we missed a lot. Due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are.
I'm just asking questions.
Yeah, you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
We'll set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I'm on
He's
Central.
Central Standard Time. You're on.
So for our next hearing, an end date supervised by the Department of Corrections. Alright guys, shifting scenes now, and this next case hits with a twist. The prosecutor offers a deal so clean and beneficial it almost sounds unreal, yet the tone in the room hints that not everyone grasps its value. As the terms unfold, you can sense the tension creeping in, because a chance like this is rare, and the weight of misunderstanding is already starting to show.
And I am the attorney for the plaintiff.
All right, and it appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right, and do I have Jennifer Moore on the Zoom?
Yes, good morning, Your Honor.
All right, thank you, Ms. Moore. Good morning to you, ma'am. All right, and it appears that the plaintiff is moving. That's right there. Yeah, well, no, I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Ma'am, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVMV funding when I checked my credit score. And that's how they were able to reach out to me. They were sending information to a different address. And according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail and so on. So, and I reached out to the creditor and they said that they gave my account to Midland. I have since resolved the issue with Midland and it is paid. I then reached out to LV. They failed to give me all my information document needed. And now we're here. So I apologize for not appearing in court.
I spoke with my public defender, and Endit has done exactly what he's supposed to do for you. Buckle up, guys, because this is the moment everything unravels. The defendant pushes back, unsure, insisting he doesn't agree with the terms that were meant to help him. The judge's patience thins as he clarifies what should have been obvious, turning the exchange into a collision between confusion and opportunity. It's tense, uncomfortable, and almost hard to watch unfold.
For LVMV funding since November of 2023. I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so the case continued. I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. she told you at that time to my appearance attorney that, according to her argument, that, quote, the matter that's before Your Honor was with Midland funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
this case was argued. I'm not done, madam. The case was continued to press, and so here we are now with good.
Mr. Rosen, I'm
I'm
stopping
getting
you. I'm stopping you because your device is breaking up. And that's what the defendant was saying, is that she's not able to hear you. It was going real smooth there until about that last minute, and something went miserably bad. And so you're going in and out. You indicated the last thing that was clearly heard was that you prepare to offer a satisfaction of judgment. You said only about $89 or so is owed.
Yeah,
But
exactly. Yeah, that's right.
after that, we weren't able to hear you very clearly.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment. Well, I'm prepared now to file a satisfaction of judgment because it's all paid. I have no idea what Ben is otherwise arguing about, but on that I rest.
Well,
Let me ask-
for the rest of Your Honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's something about Midland here. Have you seen anything that shows a debt satisfaction regarding any claim, any indebtedness with Midland?
Yes, that's what you need to do today.
Yeah, but I'm saying, have you seen anything along those lines?
This case is never with Midland Funding. I don't represent Midland Funding.
Okay, well, but you understand my question, right? Have you seen anything from Midland as a part of your file or anything that shows that this debt is satisfied?
Well, I'm going to satisfy it now, but if she's saying that she paid this bill through Midland Funding, this case is never with Midland Funding. This is more or less a first assignment from Credit One Bank to LBNB Funding, and that's it. This is not a case that went passed around the room like last year's potato chips. It's a one-time assignment from Credit One Bank to Midland to LBNB Funding. Midland Funding.
Let's set it for May 5th and end it to have this case thrown out for free. Alright guys, this part shows how even scheduling can become a battlefield. What should have been a simple calendar check turns into a string of misunderstandings that spotlight just how unprepared the defendant is. The judge tries to anchor the process, but the disconnect is impossible to ignore. You can feel the missed opportunity growing with every second of this exchange.
I'm back
Your
to you
Honor,
this morning.
may I?
Yeah.
Thank you, Your Honor. And I agree with you. I also reached out to the original creditors. That's why we're here now, Mr. Rosen, because I did reach out
That's
to.
Rusin, ma'am. Rusin.
Oh, many apologies, Mr. Rusin, Attorney Rusin. I reached out to the original creditors, and they stated that my account was given to Midland, and that's where my account set. Now, however, you guys transact the assignments on collectors end, that's not my specialty. That's not my profession. However, that debt was, and as of this debt, my checks are not getting garnished, so it's paid in full. There is no remaining of $89 because it has already been taken out. And moving forward, for the record, Your Honor, if they can just, what I've been requesting and asking is a debt of validation. I'm asking for the payment history. I am asking for a signed copy of the signature where with the contract of my signature. I'm asking if there was any insurance claim. These are my rights to ask. You guys, LVNV, should provide me this information. Now, the debt has been paid, but for the record, Your Honor, for my records, may I have this information?
All right, and it appears. An end it, but I am here now. Buckle up, guys, because the tone shifts again, this time into something heavier. As she explains why she missed the court date, there's a raw honesty that cuts through the formal setting. Her words reveal real hardship, real struggle, and a plea for understanding that many wouldn't voice so openly. Whether it's enough or not, it's a moment that grounds the entire case in human reality.
All right. All right. Thank you, ma'am. The central issue addressed by the motion in this matter is a motion to try to set aside a judgment that was entered by default in this matter. There would have to be a showing of good cause and a meritorious defense. And I've read the motion, I've listened to the arguments. I don't see a showing of any meritorious defense to the claim. Moreover, obviously, sickness would constitute some basis for showing a good cause, but you have to have both items, good cause and a meritorious defense. The whole notion of backtracking in this case prior to the entry of the judgment and demanding documentation of the debt and so on and so forth. None of that is relevant to the motion to set aside the default judgment. It's just the default judgment, you have to address the issue of whether or not there's a meritorious defense and affidavit to support that. And there simply isn't. And for that reason, after further reviewing this matter, for that reason, I don't see a basis for setting the judgment aside in this matter. It does appear that the defendant is entitled to a satisfaction in this matter, and that should be forthcoming from the plaintiff. If it's not, then the defendant may present to the court an application for satisfaction. I saw that there was something presented with the motion that was not in the form that is required post satisfaction of the judgment. That was a form addressing satisfaction of a judgment in relationship to Midland, and Midland is not the plaintiff before this court. So that's my determination. The motion is denied. Again, it seems that this is at the end of the road, and I look forward to receiving a satisfaction judgment to close this out.
The whole notion of backtracking, and end it to close us out. All right, guys, this final moment brings everything crashing back to strict legal standards. The judge lays out exactly why the motion can't be granted, leaving no room for interpretation. His explanation is firm, methodical, and definitive, closing the door on any remaining hope for reversal. And with that, the case reaches its final turn. Thanks for watching. Don't forget to like the video and subscribe to the channel, and we'll see you in the next one.